Okay, so it's my great pleasure to introduce our next speaker, Dr. Dora Kostakopoulou, who is a chair of the Scientific Committee of the Fundamental Rights Agency of the EU and also a professor at KU Leuven University in Belgium. So her works in academic human rights have been published in numerous books and journals. She has also received several awards for her research, including the Art and Humanities Research Council's Innovation Award. Dora, the floor is yours.
Thank you very much, Morteja, and good afternoon, everybody. Very nice to be with you, and thank you so much for the invitation. Morteja and I have been working on the issue of bullying for almost a year right now. And during our discussions, we felt very, very strongly about the lack of protection for targets. And as I have been working at the Fundamental Rights Agency of the EU, and I have a sensitivity towards human rights abuse, we realized that there are a number of human rights violations which are involved in bullying, and therefore it might make sense to reframe bullying as human rights abuse. So what we're trying to do in the context of various pieces that we're doing right now is to identify specific provisions of international human rights law that are involved in bullying and to bring those into the open. So today, Morteja asked me to talk about this kind of research that we are doing on human rights and bullying. And I've sent to him two diagrams that we have done, one table that includes a specific provisions of international human rights law. And here we're using the Universal Declaration of Human Rights. It is wonderful. Article 1, everyone is, equal in dignity and rights, free and equal in dignity and rights. And bullying is essentially an assault on human dignity. And the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights. Then we look at two European instruments, the European Convention on Human Rights and the EU Charter of Fundamental Rights. So in Europe, the EU Charter of Fundamental Rights is the most advanced supranational Bill of Rights, Europe's Bill of Rights. It includes a number of rights which are not included in the European Convention of Human Rights and other instruments, including the right to data protection. And they make data protection a fundamental human right, which is also very interesting for bullying because targets face false charges, false accusations, and therefore the processing of personal data in a very unlawful way. So there is a possibility of using data protection law in order to protest against unlawful processing of personal data, also to request correction of inaccurate information, and therefore to foil attempts by university managers to instigate disciplinary action against you on the basis of false accusations, to instigate suspension, and so on and so forth. So we're looking at all these possibilities of various pieces of legislation that might help protect targets better. Now, Gary gave a fantastic speech and mentioned this division between public and private universities. And this has always been the problem. And when we're discussing human rights law, of course, the traditional view is that this applies only to states, and they have this threefold duty to protect human rights, respect human rights, and fulfill human rights. Like three legal obligations. These are distinctive legal obligations and the legal duty of care. But at the same time, this division between public and private universities tends to be eroded. And here there have been a number of progressive developments that have taken place at the level of the UN, because the UN Working Group on Business and Human Rights created in 2011 the UN Guiding Principles on Business and Human Rights. So we have an international instrument of the Guiding Principles on Business and Human Rights, which rests on three pillars: states and their duty to protect human rights. Then the second pillar of corporate responsibility to respect human rights. So it's not as strong as states, but they have a legal duty to respect human rights. And this means the application of the principle of due diligence. And this is the legal principle. And the third pillar on targets of victims' access to effective remedy. So in order to give you an idea about these guiding principles, and these are wonderful developments in international human rights law, which ensure that the private sector meets its responsibilities to protect individuals from human rights abuse, is Principle 17, which states that in order to identify, prevent, mitigate, and account for how they address the adverse human rights impacts, business enterprises should carry out human rights due diligence. So this is a legal principle. And similarly, the UN Guiding Principle 25 states that as part of the duty to protect against business-related human rights abuse, private universities, business-related human rights abuse, states must take appropriate steps to ensure through judicial, administrative, legislative, or other appropriate means that when such abuses occur within their territory and or jurisdiction, those affected have access to an effective remedy. So even within the domain of private universities, states can do quite a lot to ensure that they comply with UN Guiding Principle 25 and that the victims have access to an effective remedy. Now, the guiding principles do not define the term abuse, but international human rights law defines it as follows: any activity or act aimed at the destruction of any human right or freedom or at the limitation to a greater extent than is provided by human rights law. So we have a definition, and we have also the UN draft of international legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. It's a very, very big term that defines the term human rights violation or abuse as follows: any harm by a state or a business enterprise through acts or omissions in the context of business activities against any person or any group of persons, individually or collectively, including physical and mental injury, emotional suffering, economic loss or substantial impairment of the human rights, including environmental rights. So international human rights law, in a sense, has evolved quite a lot to incorporate very, very workable definitions of human rights abuse, and also to bridge the gap between the private and the public sector. And therefore, we can use these UN guiding principles developed in 2011 to say that private universities have a duty, legal duty, to respect human rights and to ensure that the principle of due diligence applies in their operations. And furthermore, the states can exercise oversight over their actions by providing the targets with an effective remedy. So in a sense, by doing this, we managed to evade the criticism that, oh, Mortej and Dora, what you're doing with international human rights law applies only to public universities and not to private universities, and to bring them together in order then to be able to identify the human rights articles that are involved in bullying. And there are many. And let me define bullying and harassment before I start, because we have included this, and there's a wonderful definition of bullying, which includes 3 different elements. The first one is repeated health-harming mistreatment, verbal abuse, or conduct which is threatening, humiliating, intimidating, or sabotage that interferes with work, or some combination of the 3. Academic harassment, on the other hand, refers to protracted or repetitive aggressive acts and communications coupled with systematic and progressively escalating pattern that causes fear, distress, physical, mental, or psychological injuries to the victim. So here, as you see, I have the 4 international human rights instruments there: the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, Cultural Rights, the European Convention of Human Rights, and the EU Charter of Fundamental Rights. And the article that protects human dignity comes right at the top. And in terms of the EU Charter of Fundamental Rights, the protection of human dignity is an absolute right. It cannot be limited. No limitations are allowed. So if somebody breaches your human dignity by making all sorts of outrageous false allegations about you, in order to discredit you, in order to defame you, in order to dismiss you, in order to destroy your life and your career, you have the protection of Article 1 of human dignity, which is an absolute right and can bring an action against the university. So that's why the bullying operations here I have included at the top slander, and Gary mentioned this as well, because this occurs quite a lot in the context of bullying. False accusations, constant criticism, undervaluing contributions, taking credit for the target's work or not giving due credit to him or her, inappropriate monitoring, which is also violation of human dignity, spying on individuals. So you might have colleagues spying on you and conveying this information to managers. You might have IT departments spying on you, on your communications, in order to identify possibilities for adverse action against you. For example, you are away attending some conference, and the manager can use this in order to send you an email, and of course no reply is being received, and then this is perceived by him as an attempt to defy his management and for him to embark upon disciplinary action for not obeying his reasonable management request, and so on and so forth. Actualizing threats via false and justified disciplinary hearings and sanctions, spreading malicious rumors, attacks on the professionalism and integrity of the individual, shouting or yelling at the target, work sabotage, scapegoating, and so on and so forth. And then we are moving on to very small job-related attacks under 2, and we apply Article 2 on non-discrimination here, and Article 3 of the European Covenant on Social, Economic, Social, Cultural Rights, Equality between men and women, and look at bullying manifesting in terms of the denial of benefits and opportunities at work, not providing enough training, stealing intellectual work, manufacturing situations to catch the target out, being singled out. And we'll proceed with Article 12, protection from attacks on honor and reputation of the Universal Declaration of Human Rights. And here we include all sorts of the unjustified disciplinary hearings, investigations, actions, suspension, insulting comments about individuals, who they work, their associations, stalking, nuisance calls, phishing emails, spam, malware containing emails, the invasion of their own private space by having a number of unwanted calls during the weekend, late in the afternoon, and so on and so forth, which involve the violation of the right to respect for private and family life as well, and which is an article also protected by the European Convention of Human Rights and the EU Charter of Fundamental Rights. And then we have included also freedom of thought, freedom of expression, which may be, and Kerry mentioned that may be involved. And we move on with the next slide. You lost it, Morteza. With specific, yes, exactly, this one, specific social rights, like Article 23 of the Universal Declaration of Human Rights, right to work and to just and favorable conditions of work. And this is where health and safety comes into play. Or Articles 5 and 7, 6 and 7, again, the right to a safe and a healthy environment, freedom to choose an occupation and to engage in work in terms of the EU Charter of Fundamental Rights, or protection in the event of unjustified dismissal, which one does not find in other international human rights law instruments, the right to fair and just working conditions, the right to respect one's physical and mental integrity. And we know how bullying and all the manifestations of bullying affect one's mental integrity and people driven often to suicide. We have included academic freedom and freedom of the arts and sciences that could be involved. And we proceed also to examine um, what happens with respect to access to an effective remedy, equality before the law, the right to a fair hearing before an impartial and independent tribunal or a court, the right to non-discrimination, equal protection, and so on and so forth. So in a sense, there are a number of rights, which human rights law articles, which are involved in bullying, which targets could raise in order to give more substance and to signal that what they're facing is essentially human rights abuse, which is absolutely unacceptable. And even though the law, labor law, may not in a particular country um, outlaw bullying, reframing bullying as a human rights abuse make the matter quite serious. And now, in Europe, there are countries that have criminalized bullying. They have introduced legislation, and employers who are involved in bullying face imprisonment. In Germany, bullying is called psychoterror. In France, bullying is called moral harassment. In Spain, it has been criminalized, and individuals face imprisonment between 6 months and 2 years. Managers taking advantage of their superior position and performing activities which inflict damage and fear, distress on other targets, or create a hostile environment, or engage in humiliating acts which, without constituting degrading treatment, involve serious harassment of the victim. So there is progressive legislation in certain EU member states, and this shows that bullying can be criminalized. Now, if a particular country does not have a particular law dealing with bullying, as Gary said, we're using anti-discrimination law, equality law, but the problem there is there must be a protected characteristic, and this leaves quite a lot of individuals without any protection, and human rights legislation. But we could equally use data protection law, at least during the early phases of bullying, in order to stop employers from using false information about individuals or making false criticisms about individuals, and therefore individuals will claim that their fundamental right to data protection is being violated. And furthermore, they have the right to request the correction of any inaccurate data or information before the matter escalates to disciplinary hearing or investigation. And if an employer refuses to do so, this is another violation of the data protection law and the data protection principle, because these rights are fundamental rights: the right to correction of inaccurate data, the right to rectification of false information, the right to request the employer to stop the processing of unlawful collection of data. Now, what can be done? Well, human rights matter. And human rights matter quite a lot. And it's unfortunate that university executives have not paid attention to the need to implement human rights law quite effectively within their environments. Do they know that they violate human rights law when they bully targets, or when managers are involved in bullying and human resource departments actually support managers and do nothing to support the victims? I believe they do. I believe that they're not ignorant of the law in the same way they're not ignorant of professional code of conduct and ethics. the principle do not do harm to others. It's a universal principle. So when you engage in harmful activity unnecessarily, you know that you have breached ethics. You know that you have gone beyond the domain of the professional code of conduct and you're breaching the law. So they do know. The question is, why do they do it? And here, in answering the question as to why they fail to comply with the law, whatever law exists within the country, and with all regulations and principles. Um, uh, the answer to this can be found in all traditional instances, manifestations of non-compliance. They believe that they can get away with it. That's why they do it. So in other words, there is a kind of permissive bias and a kind of no consequence bias in their decision making. Permissive because they're big enough, they're influential enough, they have resources, they can subjugate the target so much that the target will be unable to take any action against them. And no consequences, they have connections, they have the best team of lawyers, and therefore nothing is going to happen to them. Furthermore, they can easily defame the target, discredit the target through various campaigns. They can ensure that the target will never get employment ever again and destroy the target's life and career. Now, bullying managers and executives within universities could stop operating with impunity if A, were more enforceability of the legal obligations and better state regulation of that. And as we saw, even with respect to private universities, there is room in the national human rights law for the states to exercise particular oversight over the actions of universities, even private universities. B, there were more publicity of what is happening, of these unlawful practices, and the naming of human rights abuses. C, if we had mandatory annual statements produced by universities, including information about incidents of bullying and academic harassment, the number of grievances which are lodged, the number of suspensions which are ordered, who gets suspended, the status of the individuals who get suspended, the duration of the suspension, the outcome of the suspension, disciplinary actions, dismissal, resources spent on responding to claims lodged in tribunals and courts. Now, these annual statements, in a sense, and the publicity associated with them would force universities to operate better and more loyally within the domain of the law. And finally, we had benchmarking of universities by human rights indications on a biannual basis. What kind of indicators could we use to benchmark universities? Now, here we have a corporate human rights benchmark, which was established in 2019 by civil society organizations and investors in the Netherlands, UK, and Nordic countries, and established a wonderful framework, which is based on indicators based, first of all, on policies, procedures, and governance. Secondly, it's conduct focused. So it's much more a kind of micro level type of indicator. And finally, outcome focused. So again, indicators do exist, which could be accommodated, could be adapted in order to ensure the benchmarking of universities. I mean, we could have also indicators on the extent to which they respect the legal principle of due diligence, or they conduct due diligence exercises, or they expect to work the extent to which the grievance mechanisms work, or the extent to which human rights obligations are being followed, or the extent to which responses to serious allegations are made in an effective and real way. So there are a number of possibilities in order to enhance the protection of victims within universities. And then if we focus on a kind of micro level, quite a lot of what Kerry said is insightful and very, very helpful. In terms of my own experiences, and here I request Mortenza to put the other slide on the signs of bullying. What was very, very important is to be able to recognize bullying and how bullying works, because it took me, I had never experienced bullying before facing a particular academic environment. And it took me 2 to 3 years, to understand that I was being targeted and I was being bullied. So I was having these questions: why is this happening? How could this happen? Why and how? But I never understood that what was happening to me was bullying. So we identified with Morteza 5 very important early signs of bullying, and we call them the greed techniques. Uh, um, and we started with goading, um, which is so prominent in bullying, and the bullying intentionally provokes the victim into a response which would be used against him or her in the future. And it is so prevalent that individuals need to recognize instances of goading and how they're going to respond to this, and therefore to refrain from sending this irrational email which could be used against them, or the irrational complaint, or the aggressive complaint. Um, the second one is the recognition of gaslighting and what happens with gaslighting. And here, um, uh, it is important to remember that gaslighting operates on a kind of psychological level in order to distort the sense of the reality of the victim. So the victim becomes more amenable to the abuse um, of the manager. Um, um, and this is GG, the greed techniques. R is a common tactic of reversing the victim and oppressor position, whereby the manager appears to become the victim, and the victim becomes an oversensitive and uncooperative, unwilling person, who easily misinterprets simple mistakes and engages in critical comments and makes persistent complaints and communications. This is a very, very common technique. We find it also in coercive control situations and domestic abuse situations. These are exactly the same because the aim, because they involve power imbalances. Essentially, this is a game of power, and this is a game of disempowering the individual and fully subjugating the individual. So, by gaslighting the individual, oh, is this really what happened? Are you sure that this was not a mistake? Um, um, aren't you very, very sensitive about this? And so on and so forth. The third one, the third was reversing. The fourth one, isolating the victim. Again, this is common in domestic control and coercive control situation. Isolating the victim. So, if within a particular work environment you realize that you're not invited to participate in various meetings, or you're sent false information about meetings that never take place, you are excluded from various teams, you're excluded from various events, you don't receive information about things that are happening, and therefore you don't feel that you are a member of the team, that this is also a conscious strategy of erasing your bonds with the team and the possibility of complaining to others about what is happening to you and isolating you. And therefore, by isolating you, you do not have any networks of support in the difficult situations that you're facing. And the final one, the final technique, which is discrediting and defaming the victim. These are the clear dignity attacks on the victim, but criticizing the victim's performance, criticizing the victim's conduct, making fictitious allegations, interpreting, I don't know, harassment as a manifestation of sending an email that wishes somebody a good weekend. It has happened. It has happened. I have seen instances whereby very polite emails are interpreted as harassment, without any justification, without any rationality. all that is happening is an attempt to discredit and defame them. Now, if you are sensitive and you're able to recognize these signs of bullying, you're able to respond to those adequately at a very early stage. So, what is the best response? Now, here we have the classic dilemma: flight or fight. Now, much depends on the situation, which path you're going to follow. Morteja, in various publications, has advised flight because this, particularly with respect to younger academics, it's a way of them restoring the sense of dignity and self-esteem and continuing with their lives and their careers. In other situations, in terms of more established academics, a fight might be important because change needs to take place. But there are intermediate, let's say, paths as well of selective engagement and disentanglement, partial disentanglement. I don't want to be really dogmatic in terms of fight and flight only, and getting advice from a solicitor as well, from an advocate might also be important. But for me, as I saw, the recognition of the signs of bullying was the first, most important attempt that I made in order, first of all, to understand what was happening to me and to find ways of fighting against it. So increasing awareness about bullying and the work that you have been doing is very, very important, and as important as finding legal avenues in order to protect victims and ensure a safe and respectful work environment. Yes, thank you.